Jabalpur versus Shiv Kant Shukla. A.D.M. Jabalpur versus Shiv Kant Shukla, 1975. Never forget this case. Whenever you are reading about national emergency, A.D.M. Jabalpur versus Shiv Kant Shukla is very, very important. Listen to the background of the case and the case. As you all know, the Allahabad High Court declared Indira Gandhi's election from Rai Bareli was unconstitutional in 1975. Indira Gandhi's election from Rai Bareli was declared as unconstitutional. Yesterday in basic structure theory we have discussed rule of law and free and fair elections. After this declaration by the High Court, Indira Gandhi approached the Supreme Court and she got a stay. After that, on the ground of internal disturbance, emergency was imposed throughout India, and after emergency was imposed on June 25th, on June 27th, a presidential order was made. On June 27th, a presidential order was made. No writ of habeas corpus, no writ of habeas corpus would be maintainable against any arrest or detention. No writ of habeas corpus would be maintainable against any arrest or detention. This was the presidential order. What is habeas corpus? To produce the body. That means that during national emergency, at this time in 1975, the government can arrest or detain any person and put him in jail. You cannot file a habeas corpus petition. This was the order given by the president. This was the order given by the president. No habeas corpus, no petition should be entertained by the court. And many people were arrested and detained under many laws, preventive detention acts like MISA. Journalists were arrested, opponents were arrested, many arrests and detentions were made. For no reason opponents were arrested sometimes. All these things were made during emergency. Then 9 high courts in India said habeas corpus petitions can be maintained even during emergency. 9 high courts in India said habeas corpus petitions can be maintained even during emergency. That means even emergency cases, the basic right of citizen to produce a body, to have your own body, not to get illegal arrest, was allowed even during emergency. This was a judgment given by 9 high courts in India, and government went on appeal against the judgments of 9 high courts. Government went on appeal against the judgment of 9 high courts. And then what happened? There were 5 judges in the Supreme Court. There were 5 judges. Justice Chandrachud, Justice Bhagwati, Justice A.N. Ray, Justice Beg, Justice H.R. Khanna. There are 5 judges. Out of 5 judges constitutional bench, 4 judges, Justice Beg, Justice Chandrachud, Justice Ray, Justice Bhagwati, said that no habeas corpus petition can lie. No habeas corpus petition can lie during national emergency. You cannot claim your civil liberties. You cannot claim your habeas corpus during national emergency. The dissenting judge, only one judge, H.R. Khanna, said even during emergency habeas corpus petitions lie. But the majority judges, 4 judges said habeas corpus petitions cannot be valid during national emergency. This judgment is the most debatable and most controversial judgment during national emergency, where a constitutional bench strongly declared that under emergency no one could seek the assistance of any court. Under emergency no one could seek the assistance of any court in India to try and save his liberty, if it is taken away by the state. This is the serious case of, important case of A.D.M. Jabalpur versus Shiv Kant Shukla. Okay. So, this case is a glaring example of how the judiciary have interpreted the order in letter but not in its spirit. The presidential order says no habeas corpus. The spirit of personal liberty, the spirit of constitutional freedoms were not taken into light. Only literal interpretation of law was taken. So, this judgment, many experts say it is not correct. This is called A.D.M. Jabalpur versus Shiv Kant Shukla or habeas corpus case 1975. Without this case, there is no answer of national emergency. And remember,